type of penalties can be imposed by the adjudicating authority and by the RERA towards the builders or agents. They can be 10% of project cost can be taken up as a penalty. Other penalty that they can be imprisoned as well for up to 3 months, 3 years. That they can be imprisoned 3 years. They can be imprisoned. Then what type of drastic penalty that a home buyer or builder faces in case he does a lot of there are a lot of home buyers who have a grievance against it is that they you know can they their registration of RERA can also be cancelled. This is also a penalty that can be given by the adjudicating authority to the to the promoters and builders that even their RERA licenses can be cancelled. And this is and this is not a very hardest task. Once a RERA registration is cancelled, then the builders and the promoters, they face a lot of loss due to this only. Okay, then basically the appeal process. I think everybody knows that you can, if you want, you can file an appeal in the RERA appellate tribunal within 60 days. If you don't, confirm with the, if you don't confirm with the, basically what the RERA, whatever the dispute resolution system of RERA was, and you think that you are not fully satisfied with that. So within 60 days after, you receive a formal, formal judgment type of thing, formal, judgment in your complaint, then you can, you are eligible to file appeal to the RERA appellate tribunal within 60 days, and if you guys want, you can, even file an appeal in the High Court as well. High Court also has jurisdiction on some RERA matters within the specific time, the specific, jurisdiction is there, but, you are eligible if you think that the tribunal is, they are also not, doing their task arduously. So you want, you can, even file a, appeal in the respective High Court of the state, wherever you guys are practicing, or, wherever the building or the property was situated. You can even go and, file appeal there. Okay. So as far as I think that I have basically told you the very simple basics of complaint, and I don't think that it is something very technical or difficult. This was because before starting with the draft, I like is that people, they must understand the specific things that are there in the draft. Okay, so as far as I think that I've covered all the important points, and in very simple terms, in very very common words, I've explained to you guys. I have not used any kind of legal terms as such. So let's just if you guys okay, let's just do this. I'll just teach you the draft. Then at the end we'll take up questions. Okay. So if you guys have any question, you can just take it up with me in the end. Okay. So now I'm wait, I'm just sharing my screen, and I have the draft with me. I'll show you the draft. Show the draft to you guys. Okay. Okay. Wait. Yes. I hope my screen is visible to you guys. Yes. See, this is the draft that I have with me. This is a very simple complaint draft. This is how we draft the complaint in the tribunal that we have here. Okay. So I'll explain to you guys and keep highlighting with this with my marker draft. So the first and basic important thing is what you write. See, now I'll teach you the basic important aspects of drafting. Okay. So in order to become, in order to learn drafting, what basically I tell everyone, what I tell my juniors and what I tell the junior advocates who try to join the high courts is that before starting with the draft of not just RERA, of any type of draft that comes before you, any type of draft, even it could be a simple complaint of rent agreement or something like that, or even a simple FIR format, something like that. So what basically you guys must understand is what you guys must know is the basic nuances of that law. So, in order to draft any agreement or draft anything, you must have a basic understanding of that subject. This, I think, is very, very important. This will not many students, not many lawyers, they take this up in the very beginning of their careers, and they face a lot of problems. In the coming years, because they don't have their foundations are not very much built up, and they try to they try to make drafts not with the conforming with the law. Okay, so this is the basic what we write is where we are filing this complaint. Here it is written before the Real Estate Regulatory Authority, Uttar Pradesh. This we write in every type of draft. This is a very simple thing. We write in the exact same format. We bold it and we put it in capital letters and we underline it. Okay. Then comes the honorable bench number. We write the bench number. We keep it blank. It is on the filing registry of the regulatory authority. They file the bench number here by themselves. Okay. See, I as a lawyer I practice in Lucknow, but as it is Uttar Pradesh, so Gautam Budh Nagar is also mentioned here. But it is fine. Complaint number, this is also allotted by the registry to you guys. Okay. What is important here is then you write in matter of. These are very, very important. If you just miss this, that in matter of, you don't know what repercussions this will happen. What will happen is that defect will happen in this complaint. Even yes, defect can happen in this complaint, and you will be called or you will be emailed that the complaint that you have filed is basically defective, and you have not drafted in a specific format. So this is why these are very important things. Okay. So Acha, before going further, do you guys know why basically drafting is done? As I'm teaching you draft today, so why basically in courts we have a specific draft for everything. Why we have a specific draft of format? Why we have a specific draft of appeals in high courts? Why we have a specific draft of filing a case in civil courts or normal courts? Why for everything the state or the governments, they have given us a specific draft for everything? Why it is there? What is the basic thought process behind doing this by the state? What was the thought process? Can anyone tell us what is the basic thing? Why is the draft is given for everything? This is a very, very, very common sense question I'm asking. It's not something,
to give an understanding of the situation.
Actually, the voice is cracking a lot.
To give an understanding of the situation.
Okay. 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 Anyone else?
Written form.
Written form. Okay. Some not exactly correct, but yes, somewhat right. It is in written form. Okay. Then what is the basic essence behind it? Why it isn't written form? So why not we just not write a complete specific format? Why not we just take up a paper, a simple A4 sheet paper? We write how we used to write a formal application to the school, that to the principal of Fala school, or to the Real Estate Regulatory Authority, subject matter complaint, and respected sir, this is this, and then we sign. Why not we do it like this? If written form was the basic basic thought process behind drafting, is basically everything. Why everything that is in legal essence? Why
There would be some mandatory amendment that is required to be
okay. Yes, you guys are understanding, right? Necessary amendments, that is right.
Uniformity, sir.
Uniformity, correct. That is amazing. Yeah, uniformity is also good.
Whenever there is a standard format, there is the grounds and prayers which need to be addressed, and if there is standardization for it, it becomes easier for the adjudicating authority to decide the case. That's why there is a certain format to it.
I guess that there can be no other perfect answer than what you have told us. This is the most perfect answer. Why basically drafting is done? Clarity, precision, standard format, proof, written. These are things that, yeah, I get it. These are important. But this was not the basic essence behind drafting. The basic essence behind drafting was, when a judge who sits in a court, what happens with him is, in every day he has to deal with more than, I think, in Lucknow Civil Court, a judge, a standard CJM or a standard civil judge senior division, what he has to deal with is more than 120 cases a day. So if there is no standard format for everything, what basically will happen is a judge will take a lot of time to understand what is there, to understand basically what is there. So if there is no standard format for everything, what basically will happen is a judge will take a lot of time to understand basically what is there. So if there is no standard format for everything, what basically will happen is a judge will take a lot of time to understand what is there, to understand basically what is there. So if there is no standard format for everything, what basically will happen is a judge will take a lot of time to understand That is why there are drafts of everything. This is the basic whole sole reason behind this. For every type of legal thing that you file before a court, or every type of agreement that you do with other party, everything that has some kind of legal sanction to it has a different draft. What basically happens is when a draft comes in front of a magistrate, what she was saying, that was absolutely correct. In different headings, different things are written. In grounds, specific aspects are written. In prayer, specific aspects. So what happens is when a file comes before an adjudicating authority or a judge, what happens is he does not read the whole. He cannot read a whole. It is not humanly possible to read the whole file, to read every fact and everything about the case. What happens is he asks the lawyer, okay, tell very briefly what happens. Then lawyer explains to him. Then he keeps turning pages. Then he sees the grounds. He just looks at the grounds. He sees, okay, 4 or 5 grounds are mentioned. Then he straight away goes to the prayer. He sees, okay, what the other party is demanding. He just sees the prayer. He uses his judicial mind. Whatever he thinks that if the prayer must be granted in that favor, then he grants it. If he thinks it should not be, then he rejects the entire prayer, and he says that okay, the prayer is not right. You can ask this any other. So this is the basic essence behind it. This is the very basic essence behind it. Every other thing, that basic format, precision and clarity should be there. That there is a proof of agreement, or it is in written format, and there is a less risk if every type of if everything we write it down. Then absolutely there is less risk in that. So these are things that are around this essence. The basic essence behind drafting was this only. Okay. So yes, let's come back to what we were understanding. See, then we write the name of the complainants there. Then see the complaint. We specifically write that ... complaints. This is specifically written. Then verses. We write it exactly VERSUS. We don't write it VS or V/S or V.S. We don't write it like this. In High Court, in tribunals, you guys have to understand this very very you have to take this up as very important things. If you can note it down, then you guys should write it down, that these are very basic for drafting. That you write verses, VERSUS. You don't write it in any short form. The other opposite party's name is written here. You write that ... He is the opposite party to to tell the court specifically that this is the complainant and this is the opposite party. Okay. Then you write the basic subject, written submission on behalf of the complainant, name of the complainant and complaint number. Okay, this is what you write. That this is a complaint on behalf of the complainant. Then you write most respectfully shoot. This, see, these are the things that are first, some things that are there in every type of draft that I've told you. This is something that is most respectfully shoot. We write in RERA complaints. Okay. That is it. These written submissions are being filed on behalf of the complainant for the kind perusal of his honorable authority. Okay. See, as this complaint is filed by a counsel, this is not something that is written by a simple home buyer. He goes to a lawyer, he goes to an advocate to file this type of complaint. So basically, what the counsel does is that he writes, the first line is that these written submissions are filed on behalf of the complainant for the kind perusal of the honorable authority. Okay. For the kind perusal basically means is for the honorable authority to basically understand the kind perusal for his perusal. Then we have specifically, we give headings, introduction. See, this heading is there. That the complainant, name of the allottee, co-allottees if there are other allottees, have filed a complaint before the Honorable Real Estate Regulatory Authority, Uttar Pradesh, under section, you write the section of Real Estate Regulatory Act 2016, as under section 31 only complaints are filed. Okay. Give me a second, okay, I have to bring some more. Okay. Just give me a second. Okay. Let's come back. Yeah. So we write that the complainant, we write his name, the allottee's name, and you write that he has filed a complaint with the Honorable Real Estate Regulatory Authority under section 31. You mentioned the section number, specific section 31. Okay. See, in all type of drafts, in what type of thing, what type of specific aspect of legal term that you are dealing with, you write the specific section in every type of draft, not just in RERA draft. In writs, what we do in high courts, in second appeals, in appeals, in any type of application, substitution application, whatever it is, we write this specific section under which section this is being filed. Because every high court act as this is as this is something as a power given to a complainant, so you have to mention to the court that under this section we are invoking the power that you have given to us. Under this section only we are invoking. Okay. You write this, then you write the bearing the complaint number. You write the specific complaint number over here. Okay. Then you write the relief. Specifically mention the relief that the complainant having sought following relief from the honorable authorities in the aforesaid complaint. The relief I've already told you. It it could be compensation, it could be refund, it could be getting the position, timely position. You can write any type of relief that it depends upon the it depends upon the complainant to complain what type of grievance he has. So it will depend upon the client that you guys have. Okay. Then we write the facts. See, we don't specifically we don't write the facts as a first heading. See, as a specific draft is there of a complaint, then the legislature must have thought about it. Why only introduction is written first and not the factual matters? So this is we also have a logic behind this as well. I'll teach you this logic also. Okay, why introduction is given first? Why not the facts? Then the introduction, then relief, or why not introduction, then facts, then relief? Because relief is something that is asked after explaining something. So why relief is given first and facts are given after the relief? This is something that I'll teach you later. Okay, this is the then facts of the complaint. Okay, then see here what you do is listen to me very well and remember this. As long as you are in this field of RERA, or as long as you are thinking about practicing law in India, or thinking about being a lawyer here. Okay, always remember, we write the facts in any type of agreement, any type of draft, in any type of thing, because this is something that I have learned by doing a lot of mistakes. That is why I remember this very very much clarity about this. You write it in specific points. Okay, specific points. You don't write it in paragraphs. You take up any draft. You download any XYZ draft from your from a Google. You do anything. You will find that draft. In that draft, there are specific points. In point wise, the draft is. There is also a aspect behind it as well. Okay. Firstly, point number one, that the complainant has applied for the allotment of plot. You write a basic factual matrix that a plot he has applied for this plot. The name of the project you write, then the number of opposite party you write, then booking amount that you have paid to the opposite party to whom you have paid the booking amount. This is the basic factual matrix you write in the first paragraph of the complaint. Okay. Then you basically tell everyone about that an apartment plot, villa bearing number this is was allotted to the complaint by the opposite party. Wide allotment letter. You write the letter dated when the allotment letter you receive pursuant to the application dated this. Firstly you would have applied for this, then only you receive the allotment letter. So you write pursuant to the application this. Okay. But at this juncture, it is pertinent to mention that the total cost of the set of applicant plot is rupees 50. You write the cost as well. As per the allotment letter that is given to them, then the complainant for the same sum of rupees 50. Opposite party till date according to the agreement of sale executed in the complainant. These are the basic simple factual matrix. This is very basic English that is written here. Okay. Then point number third, that as per the clause this of the allotment letter, as allotment letter there are this is why I was not explaining you why it is done point format. See, here it is written that as per the clause this, the agreement, the allotment letter which was received by the home buyer, that was given to the home buyer by the builder, by the promoter. That letter must have also been in the points only. See, every type of legal thing by the promoter be written. That letter was must have also been in the points. Here it is specifically written that as per clause like 1, 2, 3, or ABC, or 1.1, 1.2, 1.3, what was the relevant clause was there in that letter of the allotment letter, builder buyer agreement for sale, brochure, prospectus. That is why all these types of agreements, all these types of drafts, they are done in specific numbered points. They are not written in paragraphs. So as to create a clarity in the minds of the judge, as well as the other party. Okay. So when this complaint will come before a judge, he will see the point number 3. He'll see, okay, In this point, it is as per clause this. Then what he'll go do is he'll go to the next years. He'll find out the allotment letter. He'll open the allotment letter. He'll go exactly to that clause. So you won't have to write whatever was written in that clause exactly here. You guys understand what I'm trying to say? You won't have to write what was given in that clause here so as to decrease, because these types of agreement, whatever drafting is done, it is done in very much clarity with it is not an essay. You don't write everything in detail. You write it in detail, but you do it in specific crux points. You don't write each and everything. It is not a letter that you are writing to someone else. So you write it in specific format in a specific points so as to make it so as to increase the clarity of that. That is why this is written in points. Okay. Then that opposite party offered the possession of allotment bearing number to the complainant. While later we have written dated as well. However, the complainant got the actual possession of the opposite plot. This on this. We write the actual date when the possession was received. Okay. Then that opposite party applied for obtaining the completion certificate or occupancy certificate. See, once the possession is given, then the opposite party, what they do is they apply for a completion certificate or occupancy certificate. So, okay, we write the name of the competent authority here. This paragraph is applicable only for the cases where the complainant has knowledge of this fact. See, this is something that is very simple. Then you come to point number 6. It is written that on several occasions the complainant requested the opposite party through email or any other medium to hand over the possession of aforesaid unit or refund the amount paid to the complainant or opposite party, the case may be. See, now you are writing specific facts. First, see, in this format, firstly you gave an introduction. Then you told the adjudicating authority about the relief that you are asking. Then in facts, you gave the basic details of property, the basic details of the opposite party. You told about everything. Then you come to the exact dispute. Before coming to the dispute, you are basically telling that on several occasions, what you did is you actually contacted the opposite party via email or via any other medium. You attached, if it was done via email, you attach email in a relevant annexures. See, one important thing about annexures is also there is that in drafting, annexures play a very important role. See, you cannot basically attach all the documents after after drafting something. You have for specific documents, you make a specific annexure. Okay. Annexure is nothing, it is just numbered documents. What basically happens is when this case will be filed, what will happen is after this case is filed, not after this case is filed, then after this complaint is drafted, what happens is whatever the documentary evidences that will be provided to the counsel by the complainant, whatever document evidence will be there, then what it does is what the council has to do is whatever the thing they were attaching. See here, what they were attaching. Here they were attaching a builder's buyer's agreement. Okay, here they were attaching They were as you see they were asking for occupancy certificate. Here they are attaching some kind of email. So what you do is you write at the end is that it is attached by annexure number 1A, attached by annexure number 1B. So what this actually basically gives a clarity to the judge so that he can exactly after reading this paragraph, he can go to that specific annexure. If it is written that it is mentioned in annexure number 2, then he can specifically go to that annexure. He can see see the basic email. He can go to that email. Okay. So annexures are also made as this is a simple draft. Annexure are not given in this, but when you start practicing, when you take up these RERA type of cases, then annexures are also mentioned there. They also play a very vivid role in drafting. Very, very vivid role. These are very basics, ABCs of drafting that I'm teaching you. Because this is not a basic drafting class, but as I'm teaching you this draft, so I don't know whatever classes I'll have with you guys or not, but I'm basically, this is my way of teaching is that I, take up everything. I try to, cover up everything. I don't need another class for this drafting. While taking this draft only, I'll teach you all the relevant things about drafting. Okay. So I have told you about the annexures as well. Okay. Then that despite several requests of the opposite party failed to hand over the possession of the posted unit, refunded amount paid complainant as a case may be. See, these are the specific facts. Okay. Then you write that the part completion certificate, occupancy certificate was obtained by this. See, what will happen is that, see, as this part completion certificate is obtained, so you attach this certificate as annexure number 1C here. Okay. So it will help the judge. So Also, we can attach annexures like this. Okay, that thereafter a sale deed, subs lease deed was executed between the complainant, name of allotee, and opposite party. You can write here. Okay, and see, these are the basic facts. So if it is an apartment, plot, or villa, and put on a complaint with this, you can also write that. If it was, in case it was cancelled or terminated, you can write this as well. Okay. Then 10th paragraph is that the complainant has received the refund of rupees out of the total money paid. If any kind of refund the complainant has received, he can also mention that in this complaint as well. See, these are the basics. These are basic factual matters about the complaint. Then comes if there is any kind of other issue that is there. If there is any kind of issue, then you write the issues there. Okay. If any kind of material facts or any kind of issue that may have arisen due to this dispute, then you can write it here. Or statutory provisions that the complainant intends to rely, you can write the statutory provisions here as well. Okay. Then comes the prayer. Very important. Judge, he just sees your introduction, he just sees your relief, and he comes to the prayer. Factual matrix, he does not read everything. He just listens to the lawyer. He just listens to the counsel, whatever he's saying. Then he comes to the prayer. What you have asked, what you have basically prayed to the court. It is therefore submitted that the Honorable Realistic Regulatory Authority may please to pass as prayed for in the complaints filed with the complaint. Okay. Whatever you have prayed, you have to, for whatever relief you have prayed, you have to write it here that what you can just request to the regulatory authority. So after looking into the facts of the case and after ascertaining all the annexures, all the documentary evidences that you have provided with the complaint, so that they can, if they are satisfied with that, then they can grant a prayer in your favor. If they are not satisfied with it, then they can even not grant a prayer in your favor. Okay. Then comes then comes now we are at the end of it. Then comes the simple date, very important. You write date, you write place, very important. This is date at this is place. This is first as date, place, wherever it was filed, and at what time, what date it was, this complaint was filed is written. Okay, not the date of the dispute, not the date when the cause of action arose. Basically, the date and place here written is the date and place of whenever you are going to the registry to file this case. Okay. Then comes the complainant. As this is a written complaint, so the complainant himself, he cannot file this case. So what he comes is, he comes through the counsel of the complainant, through an advocate of some sort. You write the complaint's name here, you write the counsel, the advocate's name here, then even you attach a wakalatnama with the complaint if it is necessary, it is deemed necessary, then a wakalatnama is also attached. Okay. So this is the basic format of a complaint. I have basically taught you the format as well as taught you the relevant things that are in the format. I have even taught you about the basics of drafting as well, and I hope that you guys have understood. I hope that you guys basically understood about this. And okay, yes. So let's yes,
Sir, I have one query.
just take up queries. Yes. Okay.
Is there any specific format given in the rules for complaint or?
See, what happens is via act, when an act is there, when an act is made, this type of format is not specifically given in that. With the emergence, with the growth of the law, what happens is these types of format, it is not explicitly given in the rules, but this is a format that is basically, this is what I can say is that this is right everywhere. This is not given specifically as a type of draft in the act, but yes, this format is taken up in every type of. Okay, it's not given as a simple draft in the act.
Like in NCLT, there is an NCLT rules. There are the formats given for the petition or application,
Yes,
where there are facts, limitation, all these clauses are there.
In NCLT Act,
it is not in RERA, right?
No, it's not.
Okay.
So affidavit in support is not required along with the complaint while filing the complaint. Affidavit in support of complaint.
Yes, if you want, affidavit. Affidavit is something that is very, very important.
No, not separate affidavit. I mean to say in support of complaint.
Yes. Simply, if you want, then affidavit in support of complaint can absolutely be there. You can then this complaint cannot be filed. You have to make a specific index. You have to write first that is complaint is attached, then affidavit in support of complaint is attached. Then you can write the relevant annexures. Then you can insert the wakalatnama or an ID proof as well. But
Yes,
Can,
go ahead.
can you share a draft of what you have just put up, because it wasn't clear at all?
Yes, yes.
That is
Okay.
one. And
Okay.
second, sir,
Yes, sir.
I have a second question. Can I just ask it?
Yes, absolutely.
So,
I will this draft that I have taught you guys, I'll send it to the admin. Okay. So
Yeah,
I hope that she can share it in the relevant WhatsApp groups with you guys. Okay?
I have the first question, which actually stems from the earlier question, which
Okay.
was that when he mentioned about the affidavit in support of the complaint, is
Mhm.
that a necessity, or it is really entirely up to us of whether I need to attach it? That was the question firstly.
Okay. See, firstly, before going into the depth of it, I'll basically tell you in very simple words what basically an affidavit in support of complaint is. See, affidavit is something that, how can a judge with your complaint, how can he understand that whatever you are saying is right? For that only an affidavit is attached to the complaint. This is something that should absolutely be there. But it is not a defect. See, can you understand what I'm trying to say?
Yes.
That complaint, affidavit in support of complaint is something that is, that is an absolute necessity. But if in case affidavit is not attached, then this will not come up as a defect. After filing this complaint, this will not come up as a defect. This basically affidavit is basically done. What we write in affidavit is that that the complainant is well acquainted with the facts and circumstances of the case. When you write that in case any discrepancy in these facts come into the knowledge of the adjudicating authority, then it will be the responsibility of the complainant, and he will take back the complaint. Something like that. You write. I hope everyone basically knows what to do with this.
So my question, sir, is that is it mandatory? That's the question.
Yes, you should. I think, as far as I can tell you, then you should, in before filing a complaint and while filing a complaint, you should absolutely attach an affidavit.
So, sir, in your draft which you presented to us,
Okay.
Can you please send us a complete draft of the complaint?
Absolutely, sure. Yes, I will attach an affidavit in support of complaint.
All right.
See, this affidavit in support of a lot of applications, a lot of things are done. This is not just simply done with complaint only.
Okay.
In a lot of high court cases, this affidavit is attached. Okay, that is why I did not include this affidavit in this format of complaint, because it is simply there. But I will, if you are asking, I'll send it. Okay.
Yes, that is done. And sir, you mentioned that the complainant cannot sign because it has to be through a counsel. Again, not necessary.
See, no, I did not say this. I say what I said, the complainant has to sign. Then, as he is not a legal officer of the court, then he is signing through then the advocate has also.
No, sorry, sir, I didn't frame it right. My question is that can a person do so without the counsel?
See, I don't think so. You should not. Because, see, there are two things why you should not do this. Because, firstly, as a common layman, he does not understand what are the basic nuances of this. Okay, so what should be done is, as if there is any kind of grievance that a complainant must have, he should absolutely go to a lawyer. His lawyer, as he is the officer of the court, he is not, not everyone. You cannot go yourself and file a case in the high court. You have to have, a client, an advocate to represent yourself. Similarly, likewise, in complaint case also, you have to have a counsel to represent yourself. Okay, you cannot go to. It is not a in party hearing. These types of hearing are not done in party. The party is not responsible to come to the judge and to explain the facts. These are done as the lawyers. They are officers of the court. That is why these things are done by a lawyer. Okay.
Thank you. Sir, I have another question, but I'll take it later, if you permit later.
Okay.
Sir, I have a question.
Excuse me, sir.
With respect to this complaint in RERA.
See. Do one thing. What I'll tell you. Okay. Write your questions in the chat. I'll address. I'm not going anywhere. I'll address each and every one of them. Because this is creating a sort of situation, because like everyone wants to ask something. But yes, you can write your questions in messages. I'll take up the message and that exact number. Okay. I'll take up the question first, then another question, then another question. Okay. Just do simply write your question in simple terms in the message. I'll take it up. Don't worry. Okay. Okay, so I can see that Ankita Roy, she has asked how a promoter is different from a developer. Okay, see, what a promoter is, what a developer is. A promoter is basically a person or a company that basically constructs and develops, or sells the real estate project. That is a basic definition as per RERA of a promoter. Okay? He is a builder. And a developer comes under the ambit of promoter. Okay? As in a Venn diagram, you must have understood that promoter is a big entity. That under the entity of promoter, the developer comes. Developer is usually a person that is involved in constructing and developing that property. Okay, so this is the basic difference. If you want to, this is basically legal status given to both these parties, and a developer basically comes under promoter. These two are similar. They both construct and develop the properties, but a developer comes under the ambit. Okay. Projects prior to RERA are covered under RERA Act. Okay. I can see, okay, a lot of questions are coming. I can just, I'm just doing some water. Okay. Yes. Projects prior to RERA are covered under RERA Act. See, yes, projects prior to RERA are covered under the RERA Act. It is not, this is not a Hindu law that this is not a prospective law. It is a retrospective law, but conditionally. The projects, not every project come. The projects earlier than prior to 1 May 2017 come under the RERA Act. But yes, if the project was completed before uh, 1 May 2017, it was completed before. See, there is a difference. If it was completed before 1 May 2017, then the RERA does not apply. Okay. Then the complaints cannot be filed under RERA. You have to go to the specific civil courts. But if the projects are completed after 1st May 2017, it does not matter when they started. It does not matter when you received any kind of the completion certificate or something, some sort of that. But yes, if the project is completed after 1st May 2017, then yes, they come under the RERA. Okay. How to make a party to the complainant? How to make a party to the complainant? I don't understand this question. What are the RERA rules and RERA Act? See, a RERA Act is a specific act that is drafted by the legislature. RERA rules are also drafted by the legislature, but what happens is RERA Act is the basic body, and rules are the arms and legs of that. What basically helps in understanding on the interpreting of the RERA Act, understanding the provisions of it. The rules basically help in interpretation. This is the basic difference of RERA Act and rules. Okay. What Vishal Basak is asking, what to do if a regulatory body doesn't respond on an application filed by developer for registration of the project. See, if the regulatory body is not responding on the application that is filed by the developer for registration of a project, then you can refile the application to the regulatory body. As a home buyer, what you can do is you can also, even as you have a locus standi here, then you can also try to find that, and try to find the nuance why it is not happening, and then you can even go to the specific civil court if you guys want, a specific high court in case of inoculatory application if the body is not functioning as per the procedure. Okay? Sir, I had a question in regard to whether the cases where people are allotted a property by DDA or Ghaziabad Development Authority or any other government organization, does provisions of RERA apply to such properties also? Yes. Yes. See, the provisions. See, how can I tell you this in simple language? See, simply understand this like this. The property are of two types. Okay. Uh, Private properties and the properties that are given by government. Okay. Private properties are the properties, the people who are the people who are the promoters, the private developers. That Ansal and DLF. These are the private developers. But yes, the properties that are allotted by the government, the RERA applies to that property as well. Okay, if the public authority is acting, if the government is acting as a promoter of that property, like the DDA that you have said, that the Ghazia Development Authority, the GDA, it also municipal corporation, housing boards. If they are constructing any type of property, residential or commercial land, then yes, they are considered. See, if you read the provision of Section 2ZK of the RERA Act, you'll understand that as a government body, they also come under the ambit of promoters. So as they are promoters, absolutely a case can be filed against them, and absolutely RERA acts as a governing body for them as well. Okay, and there are as, but the thing is that this has specific limitations to it. There are some government projects upon which RERA does not apply. Projects such as construction of station construction, anything of that sort. These projects, they don't come under the ambit of the RERA if they are done by the government. Okay, then I have a grievance against a builder who is blatantly abusing the law. I have a question which, if you permit, will okay. You can ask after I've done taken up all the questions. Okay. Does land use determine RERA applicability? Yes, yes, absolutely. Land use. See, I've told you this. In the very beginning, that if the land use, commercial and residential, these two types of land uses only comes under the ambit of RERA. If the land is being used for any type of mining purpose, or for any purpose such as establishing any industries, then or I have the example that I gave you, that for purpose of erecting a government office, or for purpose of erecting a police station, or public hospital, then upon this RERA is not applicable. So land use is very important. While I noted your advice that it is better to have a lawyer to file a case on our behalf, it is mandated by RERA law or any law to have a lawyer or any eligible to file a complaint case with the RERA. Also, to register projects with RERA, can anyone submit details for registration without that? See, I told you in the very beginning, you have an online portal as well. You have an online portal that is specifically there for these cases only. If you want, you will just log in and register in that portal. You don't need a lawyer there, as it is an online portal, like the cyber complaints that are given, that are we are in the cyber era. So all type of cyber complaints that are done online, you don't need a lawyer. You just need to register there. You have to mention the relevant details, attach a relevant screenshot, and to be displayed. Simply, if you want to file a complaint via the online complaints, then you don't need a lawyer for that. But yes, if you want to go to a court, if you want to adhere to a specific format, and when these type of RERA complaints are done in front of the educating authority, then what happens? Basically, the basically the importance of lawyer. Then small time builders are required to register with state RERA. Yes, like small time builders, they are not required to register with the RERA. Like small time builders, if you have TKDs and other people that are there, they are not required. If they make specific plots, 1 or 2 plots a year, they are not required. But yes, if you are making a housing society, if you have a big 1 or 2 acres land, or bighas of land, and you are trying to establish a housing society in that, or you are trying to sell that land there, then in that cases you are required to register with the state. But small time builders, they are not required. Okay? Is it necessary to mention carpet area as per RERA Act in the draft while filing complaint? Yes. This is a very, I'll say that if you guys want, you can mention this. The carpet area of that property, this will, increase the, the susceptibility of a judge. He will be able to ascertain that, okay, if the property is that big, then a grievance is this is a big grievance. And this also helps. Mentioning a carpet area also helps. If you want, it will, see, these types of things will depend from, the grievance of client to client. If your client is demanding you to write this, you can absolutely write. See, this is not a draft that is a specific draft that is followed. It's a simple draft. You have to write it like that. But in factual matrix, whatever you want, you can make. Okay. How to make necessary party in a complaint? See, necessary parties. There are 2 types of parties according to what we have in the civil procedure code. First are the proper parties, others are the necessary parties. See, the difference between proper parties and necessary parties is that I'll come to this question. The difference between proper parties and necessary parties is that a proper party, if the case is filed without him, then also the case does not have any repercussions. The case is basically done in that way. But if the necessary party is not there, then the case it comes to a strike court. The case does not happen without if the necessary party is not. But how to make a necessary party in the complaint, if you are asking, is that then you can add the necessary party. You can write the the necessary party. You can mention the builders. If the builders has any kind of agreement with some other person, you can write their name as well. You can write the name of the agent in the necessary party also. Like these, you can add the necessary parties according to you. As it is a private complaint, this is a complaint tendered to the court. if a person has legal basis in your case, then you can mention him as a necessary party. If not, then you have to, it will be upon you to to uh, to tell the court that why he is a necessary, why without him the case will not go forward. Okay. Then Akash got that how to start a drafting any draft if no specific format or no previous application is there, and how a person can start learning to draft any draft if the person don't have any good skills. See, basically, the thing, see, not in, if you ask me, if you ask me very simply that do I think that I have the relevant good skills in drafting, and I'll say I don't. No lawyer who is in his prime, who is even 70 years old, he can draft anything in a perfect format. There is no such thing as perfect. What things are in a draft, what are important is that you have to mention the specific things. You have to write all the essential things. As soon as you're writing all the essential things and you're adhering with the format that is there, see, there is nothing of which a draft does not exist. There is nothing in this world that exists, any kind of legal complications, any kind of application, any kind of draft of which a draft does not, or if a draft, of which a draft is not in existence. If you go to a lawyer, you will go to the court, you ask the munshis there, they specifically a draft is there for everything. If there is no draft, then you can just write the application in a very simple, specific, specific, in formal application as in that way. This is and in order to learn drafting, I think a lot of these websites I'm seeing right now. I'm also teaching. I used to last week I used to teach this drafting course to students of SRM University in the south that is there. Last week I used to teach the students there. There was a collaboration with a specific brand there as well. I was teaching this drafting. So there are a lot of drafting courses that are available online. I'm not gonna name them, but you guys can research according to you. If you find it relevant, you can absolutely take up the drafting course as well. Because in law colleges, the drafting that is teach the shitty drafting is taught. I don't care if anybody can record me and say you can record me and tell me play anywhere, but I can say exactly that in law schools drafting is not taught. And see, drafting is one of the most important things that a lawyer must understand. A lawyer must know. It is one of the most important. They teach things such as company law and sports law and aviation law. That's of no use. Drafting, that is why only this 3-year practice came. A lot of students, a lot of people, including me, as soon as I heard that there is a judgment, because I was also at one point of time in my life I was preparing for judiciary, and I am, if you ask me, I'm still, if I get a chance, then I will absolutely able to, I'm eligible to, apply. But when I heard, I thought, because if I was a recent graduate right now, then this would have come to me as a great shock. But the judges, they have thought about it in very depth. That is why they have created this practice. Because earlier, what was happening was the students, they were, as soon as they were graduating from law schools, they used to think that, okay, now I'll start preparing for judiciary. They don't used to have any kind of second option with them. As a lot of, because 90%, as there was a survey I was reading a while back, 90% of law students, they have zero background. They are first generation lawyers. So they used to just start with the judiciary preparation as soon as they used to get out of law school. They used to spend 4 or 5 years in judiciary preparation, and they used to attain age of 29, 30. They used to think, they used to look back and see that they don't have anything to fall back on. That is why this thing has created by the judiciary. They have said that you have to have a 3-year practice before even being eligible to give a judiciary exam. This is because, see, this is made as a rule. This will help students in a way that as they have 3 years practice, they keep on giving exams. In case they don't clear it, then they will have a second option. They will have something to fall back on. As they have earlier practiced for 3 years, or earlier they have gone to the courts for 3 years, then they have something to fall back on. Okay. Okay, so yeah, I was actually basically I get I get swayed away by things. Yes. So how to okay, drafting is again how AFS can be drafted in a phase-wise project. I think this is a very specific question. I don't have any much knowledge about this. That I don't even know what a AFS is. Can be draft in a phase-wise project. I don't understand. Buy a purchase plot in a project marketed as residential, applied for the land conversion from commercial institutional land to residential loop. Okay. Local agencies rejected the conversion. Does it fall under the RERA as promoter claims no fault? See, this is something that is of the case related to land conversion. Before basically telling, I can exactly tell you, I have to basically see the exact face, the facts of the case before even telling you that does this fall under the RERA or no. Because see, as this is a purchase plot in a project that was marketed as residential. Okay. Or later on, if someone is applying for land conversion of that specific residential to commercial, then I think that I have to basically understand the basics of the case first before telling you that if this will exactly follow the RERA. Then how does the land, that the farmlands layout more than 600 square yards need to be registered under RERA? See, I don't have much information regarding this. I have what information. These are the specific facts that you are asking me. I'm a lawyer of this. I am not a RERA consultant with this. I basically what I come is when a specific grievance is filed before me, I take those up. But this does farmland. I have no idea about this. That farmland of 600 yards needs to be registered on RERA. I don't have it. Okay. So thank you, sir. Is it possible to learn? Yes, absolutely, absolutely. I learned this drafting by myself only. I have a specific book. It is of 500 pages long. I don't have the book manual, but I have a PDF of it. It is in my tab. I In the very beginning of my practice, I used to take up drafts. I used to learn drafting from there only. There are specific nuances to it, but yes, I take up drafts from there only. Okay. Evening, sir, do you take on internships? As of now, see, I don't get much time from the morning 8 o'clock. I leave my home, and still right now also I'm in my chambers. So as of now I'm not taking any kind of internships. But yes, you can absolutely connect. I'll share in the chat box. I'll share my LinkedIn. If you guys want, I can share my LinkedIn here, and then let's just go with it. Okay. Okay, kindly share as a PDF. Yes, absolutely. I'll share as the PDF. Okay, sure. I'll both of these two things I'll send with the admin that you guys.
Excuse me,
Yeah.
Vatsal.
Yes.
I have a question actually.
Okay, sure.
There are in newly built bus stations and railway stations, the railway authorities and the GS, for example, the state transport corporations are leasing some of their premises for long years, for at least 60 years, 70 years, and they give contract to the developer. Sorry, a builder. What they do is they after lease that property to the individual buyers.
Okay.
So will they get covered in this RERA?
You are asking me that the newly bus stands or bus stand that are created, railway platform that have been created. So what the roadways department, what they are doing is that they are leasing the premises to
They are
the builder.
leasing the premises for a long term, for 60 years, 70 years, to a developer.
Okay.
And give rights to transfer the property to the individual devotees.
Okay.
Who wish to do business on this premises.
Okay.
Will this get covered? And if it is covered, the allotee who will be the responsible to pay the compensation or resolve the issue? The GSRTC or the developer one?
See, the thing is, under the transfer of property act that we have right now in force in India, the lease, whenever any land is leased to someone else, the ownership of the land is not transferred. Only sale is a simple way in which a ownership of a land is transferred. And whenever a sale is happening, then only I have told you that whenever a sale of residential or commercial plots or residential or commercial land is happening, then only RERA comes. But when the first thing that you told is that the land is being leased by the state transport board to the promoters, then I don't think so. This is a simple civil case. This will come under the Transfer of Property Act, and I think the RERA will not have any jurisdiction over this. I think the civil court will basically have jurisdiction, because lease is something in which you are not basically transferring the ownership of the land. For 60 years, you are just giving the possession of a land to someone else. And after 60 years, you can take it back. basically will happen here is as far as I can tell you is that RERA, I don't think so RERA will entertain this kind of complaint, because in very simple format, in very simple legal format, a lease, do you understand in common sense term, the lease is something in which just possession is transferred. The ownership is not transferred. And until and unless the ownership is transferred, I don't think RERA will have any kind of say in this. I don't think, because maybe I'm wrong or maybe I'm right, but as far as I'm able to ascertain that when a lease is given, then the property is not transferred. The property's rights are not completely transferred. They still lie with the state transport board only until unless they are leased. They can they can just for some years, for 60 years, they can give it to promoters. They can establish commercial places there. But I don't think so. After 60 years, when the lease will end, then the property will it will rightly jump back to the state department, the roadways department that earlier leased the property. So I don't think so. These disputes will come under RERA. But yes, if fraudulently the builders or the promoters, they are advertising this property as that, as the to the home buyers, that they can buy this property, then yes. If this is happening fraudulently, then yes, this can come under RERA, because this a complaint can be filed in terms of false representation by the builders and home buyers. But as far as determination of land is concerned, I don't think so. I think this will lie completely with the authority of the civil courts, as this is a transfer of property case. This is not a case of real
Okay.
estate.
The next question is that how RERA will deal with the cases like when allottees haven't paid the amount which he has promised. Simultaneously, he has also taken a fund from a bank
Okay.
to fund on an agreement for sale basis. And at one hand, surface proceedings are going on. At one hand, builder has initiated the complaint against the allottee. RERA has passed the orders. So how the end result will come in these things?
See, as far as I can tell you is that when a grievance is filed with RERA, what they basically see is they basically try to see who has or who is more at fault. Okay. Firstly, this what they basically do in simple cases, that they try to understand that, okay, if both the parties are saying that the other party is at fault, like the builder are saying that the allottee is at fault, he's not trying to pay the money, or he's trying to get out of the agreement, and the allottee is saying that the builder is at fault. So what the RERA does is that it basically compares both the two things. What it does is it basically compares, and whatever decision they take, if they think that the buyer is more at fault, then they try to adjudicate the dispute according to that. But yes, they
what practically is happening now at ground level. What I have noticed that generally in agreement for sale cases, banks and financial institutions are passing the money directly to the developer.
Yes,
they are issuing the check on the name of the developer, right?
Yes. Yes.
Okay. Builders, the builder or developer goes to RERA, made application for the cancellation of sale, the agreement for sale with the allottee, and transfer that property to someone else.
Yes.
Is there any kind of specific provision which deals with this kind of situation?
See, this can come, if they want. This can come as a fraudulent practice by the promoter and the builder, because see, firstly, because of these things, there are the importance of letter of conversion and letter of acceptance, and these things come into play. As if they have come into an agreement, they have come to an agreement of sale with one party, and that party, after coming to an agreement of sale, they have contacted the bank, and the bank has subsequently, with looking into the agreement, they have transferred the money to the builders, and the builders, fraudulently, what he does is goes to the RERA, he files a complaint case, and he will transfer the property back to someone else. Then yes, the RERA will take up this case. This is a very severe case, and I think a lot of home buyers right now.
Actually, I am asking for a specific question which deals with this kind of situation.
As far as I know,
the regulations.
I am not right now. The specific regulation is not coming into my mind. I can just tell you this, but yeah, if you want, I'll just share my number. You can, I'll just if I get to it, anything, if I find anything relevant to it, I can just send you that on WhatsApp. Okay, I'll just save your number, I'll send my contact in the chat
No
session.
issue. Thank you.
Thank you so much.
Sir, if you're okay, may I ask my question? It is
Okay. See, I have. See, the thing is, it is 9:25, 9:30. I've shared my contact in the chat box. Whatever questions you guys have, you can just send them that on the WhatsApp. Okay. I think it's not an issue. I'll take up the question. Don't worry. Okay.
thank you.
Okay.
Can I
Yes.
say? So the question basically is that if a builder has
Listen. I'm telling you, I've shared my.
Excuse me, learners. If you have any queries, you can just directly ping to Sir. Sir's contact number is there in the chat box.
Okay.
So you can, you can ping on your queries there.
So are you closing the session now?
Yes.
Yeah,
Yes.
closing it because it's already 9:30, right?
Okay. Thank you.
Thank you.
All right. Thank you so much, sir. A heartfelt thank you to you for taking the time to be with us today. Your insights on topic discussed were truly searching and thought-provoking. We are grateful for the knowledge you share with us today and the inspiration you have given to us. Thank you once again. And thank you so much, learners, for related queries. You'll get update on the group. Thank you so much. I'm ending this session.